Friends, today we shall discuss about the various safeguards against general and other special criminal laws. The cases where a person is wrongfully arrested and detained under the criminal law is a matter well talked about by many in the present day society. The Criminal Procedure Code 1973 at section 4 says, all offences under the Indian Penal Code 1860 shall be investigated, inquired into, tried and otherwise dealt with in accordance with the provisions enacted in the Code of Criminal Procedure. This provision is applied to investigation, inquiry, trial or dealing otherwise of offences under any other special criminal law also. Numerous powers have been conferred to the police in relation to registering an FIR, arrest of the accused, interrogation, investigation, submission of charge sheet and prosecution before a criminal court, and such powers are bound to be abused, which may result into arbitrary arrest and detention of persons, resulting into human rights violation. Therefore, it is imperative to carry out a study as regards the safeguards that are provided under the Criminal Procedure Code. The right to liberty is one of the fundamental rights guaranteed by the modern constitutions of all the civilized countries, so also in India. The Constitution of India 1950 contains detailed provisions of fundamental rights, and some of the fundamental rights guided to shape the criminal laws of the land. The Code of Criminal Procedure 1973 was shaped taking due care of the Constitution, and the power of the arrest and detention is provided in the Code. The Universal Declaration of Human Rights 1948, which was proclaimed by the United Nations General Assembly, declares certain provisions of the international law relating to safeguards against arbitrary arrest and detention. Further, decisional laws emerge due to the judicial activism against the arbitrary arrest and detention. Therefore, it is imperative to make a brief survey of the fundamental rights and the provisions of the Universal Declaration of the Human Rights. Reference to relevant decisional laws will throw some light in this regard. More important is to have a survey of the Criminal Procedure Code 1973, which is the criminal procedure prescribing arrest and detention, in order to appreciate the safeguards provided therein against arbitrary arrest and detention. The Universal Declaration of the Human Rights 1948, which shaped the various provisions of the modern constitutions, including that of India, declares the minimum standards to be followed by the countries in framing their constitution regarding human rights, which contains provisions for safeguarding human rights relating to arbitrary arrest and detention. Article 9 of the Declaration provides that no one shall be subjected to arbitrary arrest, detention, or exile. Article 10 lays down that everyone is entitled to a fair public hearing by an independent and impartial tribunal in determination of his rights and for any criminal charges against him. Article 11 of the Declaration provides that everyone charged with a penal offense has the right to be presumed innocent until proved guilty by law in a public trial. Further, it is also provided that no one can be held guilty for an offense which did not constitute an offense under the national or international law at a time when it was committed. Various constitutions embody fundamental rights for their countrymen and shape their constitution in the manner as provided in the Universal Declaration of Human Rights. For example, one may refer to Part 3 of the Constitution of India, wherein some provisions have been incorporated which aim at safeguarding the people against arbitrary arrest and detention. Article 20 of the Indian Constitution deals with certain fundamental principles of criminal jurisprudence. Clause 1 of the article says that no person should be made to undergo punishment for any offense for the commission of any act, except in accordance with the law in force at the time. The second clause is protection against double jeopardy for the same offense. The third clause is protection against self-incrimination. Corresponding provision has been enacted under the Code of Criminal Procedure in section 300 in more detailed and elaborate manner that person once convicted or acquitted not to be tried for the same offense. In other words, it is the protection against double jeopardy. Article 21 of the Constitution guarantees the right to life and personal liberty except according to the procedure established by law. Arbitrary arrest and detention will come under the inhibition of Article 21. Article 22 lays down the protection against arrest and detention. It has been provided that no person who is arrested shall be detained in custody without being informed of the grounds of arrest. Further, he shall not be denied the right to consult and to be defended by a lawyer of his own choice. Corresponding provision is incorporated in the Code of Criminal Procedure at section 50 that every police officer arresting any person must inform the ground of his arrest and that he is entitled to bail and may arrange sureties on his behalf. Section 41D of the Code made provision for the right of the accused person to meet an advocate of his choice. Clause 2 of the Article 22 of the Constitution lays down that every person who is arrested and detained in the custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. A corresponding provision is also enacted in section 57 of the Code of Criminal Procedure, providing that person arrested should not be detained for more than 24 hours. Further, under section 167 of the Code, a procedure is mandatory when investigation cannot be completed in 24 hours. In substance, detention of a person beyond a set period is illegal except by an order of a magistrate, and also that the accusation of the detained person is found to be well founded. The provisions incorporated in the Constitution in the chapter on fundamental right afford good safeguards, as any law which abridges this constitutional provision will be void. The corresponding provisions enacted in the Code of Criminal Procedure may be repealed, but the constitutional provisions remain sacrosanct and alive. Section 41 of the Criminal Procedure Code, 1973, confers power on any police officer under the circumstances specified therein without any warrant of arrest from a magistrate. Section 46 provides the method and manner of arrests. Under Section 49, the police is not permitted to use more restraint than is necessary to prevent the escape of the person. Section 50 enjoins every police officer arresting a person without warrant to communicate to him the full particulars of the offense for which he is arrested in the ground of such arrest. The police officer is further enjoined to inform the person arrested that he is entitled to be released on bail, and he may arrange for sureties in the event of his arrest for a non-bailable offense. Section 56 contains a mandatory provision requiring the police officer making an arrest to produce the arrestee before a magistrate without unnecessary delay. The Supreme Court's verdict in D.K. Basu was incorporated in the provisions of the Criminal Procedure Code in Chapter 5. For the first time, a safeguard in arresting a person is provided that every police officer, while making an arrest, shall first bear an accurate, visible, and clear identification of his name, which will facilitate easy identification. Secondly, prepare a memorandum of arrest which shall be attested by at least one witness who is the member of the family of the person arrested or a respectable member of the locality where the arrest is made, and countersigned by the person arrested, and further inform the person arrested that he has a right to have a relative or a friend named by him to be informed of his arrests. Section 41C lays down that the state government shall establish a police control room in every district and state level, and shall cause to be displayed on the notice board kept outside the control rooms at every district the names and addresses of the person arrested and the names and addresses of the police officers who made the arrest. Under Section 41D, any person arrested or interrogated by the police shall be entitled to meet an advocate of his choice during interrogation, though not throughout the interrogation. Section 46 provides for the manner in which an arrest is to be carried out. in making an arrest, the police officer shall actually touch or confine the body of the person to be arrested unless there be a submission to the custody by word or action. But where a woman is to be arrested, unless the police officer is a woman, shall not touch the person for making her arrest. Further, in exceptional circumstances, no woman shall be arrested after sunset and before sunrise. Where such exceptional circumstances exist, the woman police officer, by making a written report, obtain the prior permission of the judicial magistrate of the first class within whose local jurisdiction the offence is committed or arrest is to be made. Section 55A imposes a duty of the person having the custody of the accused to take reasonable care of the health and safety of the accused. Lastly, by virtue of section 60A, no arrest shall be made except in accordance with the provisions of the court or any other law for the time being in force providing for arrest. Now friends, we may conclude by mentioning that the Code of Criminal Procedure 1973 made elaborate provisions which aim at safeguarding the personal liberty and life of a citizen. But in many reported cases, growing incidents of torture and deaths in the police lockups have been noticed. These areas are also glaring examples of arbitrary arrest and detention. There are provisions in the criminal law as to the actions that can be taken up against the arbitrary arrest and detention. Some punitive provisions are also contained in the Indian Penal Code 1860, which seek to punish for arbitrary arrest and detention. Section 220 of the Indian Penal Code provides for punishment to an officer or authority who detains or keeps a person in confinement with a corrupt or malicious motive. Sections 330 and 331 provides for punishment of those who inflict injury or grievous hurt on a person to extort confession or information in regard to commission of an offence. Illustrations A and B of section 330 makes a police officer guilty of torturing person in order to induce him to confess commission of a crime. Therefore, section 330 punishes a police officer for arbitrary arrest and detention. These statutory provisions under the criminal law do not work to the expectation as prosecution of an offender is an obligation of the state, and the prosecution of the police officer would not be practicable for the obvious reason that bargaining power of the victim will not be balanced with that of the police officer who is in power. So, the public law remedy in law of compensation granted by the high courts and the Supreme Court will also be an effective remedy for all arbitrary arrest and detention, as it is against the mandate of life and personal liberty guaranteed to all that can be deprived of in accordance with the procedure established by law. Thank you. Have a good day.